What's up, everybody? We got a little surprise today. Sarah Boone was in court representing herself, asking questions to people in the courtroom on her behalf, making arguments to the judge, figuring out how she's going to handle this process. And she's already asking for a delay, which is not a surprise. We'll see if it's legit. We'll see if we think the judge is going to grant it. This is the first of many requests for a continuance or some kind of delay, in my opinion, from Sarah Boone. But we get to see her first interaction, and she is not happy, which is not a surprise. It's difficult. She's put in a difficult position. I get that. But this is going to give us a little bit of an indication as to how this is going to go and how she's going to act in front of a jury if we eventually get there, and how the court even agrees how difficult this is going to be for Sarah Boone. So hit that like button if you guys have not already. Make sure you're subscribed to our page, and let's take a look at this hearing. All right, there she is, lawyer number 9 for Sarah Boone. Let's see how she does.
Mr. Cacciatore.
Dave Cacciatore on behalf of the state.
Ms. Boone, good morning. Could you please raise your right hand so Madam Clerk can swear you in?
Yes.
Ma'am, good morning. Can you state your name and date of birth for the record for me?
Sarah Boone, 10-10-77.
We also have a representative from Prison Break Investigation. Sir, if you could come forward, please. If you could, sir, raise your right hand. Madam Clerk's going to go ahead and swear you in. All right, sir, good morning. Could you state your name for the record?
Billy Lane.
And Mr. Lane, what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
Okay, very good. The reason the court had this hearing this morning is the court has found that Ms. Boone has forfeited her right to counsel and waived her right to counsel alternatively by virtue of her conduct in this case. As such, Ms. Boone is currently representing herself. The court has been working diligently to provide you the discovery. I received your letter, ma'am, and I have reviewed it. We have not forgotten about you. It's just taken some time in order to coordinate the appropriate processes with the jail.
And just so you can see the judge's disposition, he couldn't be nicer and sweeter to Ms. Boone. He's saying, we have not forgotten about you, ma'am. I got your request. We're doing everything we can to get the discovery to you. That's the purpose of this hearing. That's why we have this investigator here. Let's explain how the process works and how we're going to make sure you get all your discovery so you can prepare for your own defense.
Okay. In conversations with the jail, a laptop has been secured and will be issued to you after USB drives are provided with all the discovery. Upon the jail's—
She is going to get a laptop and USB drives with all the discovery on there. So she's going to be able to work on this stuff. It's exactly what we expected to happen. She's got to be able to prepare. She can't fit 100 boxes anywhere of papers everywhere and everywhere and everywhere. And we'll see what she thinks about that. But this is the absolutely appropriate way to handle it. She can also either get or be provided. I would be willing to bet. I don't know if she already has this or if she requested at some point in the hearing. I actually haven't even watched the whole hearing, just clips of it. We're going to watch the whole thing here together. But she can get, a legal pad and a pen to take notes as she's looking through things, writing down bait stamp numbers, page numbers, line numbers, so she knows exactly what she wants to use as she goes through all her discovery on the computer.
Receipt of those items, the following provisions will be adhered to. The laptop, charging cable, and USB devices will be kept in the FDC main control room when not in use. At no time will the charging cord be placed in the housing unit. Upon the return of the laptop to the FDC main control, the laptop will be placed on the charging cable to ensure it is available for the next day's usage. The laptop and USB device is to be accounted for with the control room inventory. The control room DST or CO will make logbook entries for the issuing and returning the USB device and laptop. The dorm officer will make logbook entries for the receiving and returning of these items to the applicable movement officer. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to inmate Boone. The laptop and USB device will be available daily to you, Ms. Boone, between 0800 and 1600 hours. A notebook entry will be—
So that's 8 a.m. to 4 p.m. So basically a full day of work. What is that? 8 hours? So 8 hours a day. She can look at this stuff. She can review it. She can prepare. That's plenty of time. That's absolutely reasonable. Now listen, a layperson representing themselves, I don't care if you have 1,000,000 hours, it's going to be very difficult to do the job a trained lawyer would do. You care about your case more than or more than they would do, obviously, because you care about your case more than anybody does. But there's a reason why you shouldn't represent yourself. And it's not just that you don't know what you're doing, but you can also get your judgment clouded. It become very difficult. There's all sorts of just conflicts in your own mind and how you deal with things that, we don't have to necessarily dig into fully now, but she is going to have an absolutely fair amount of time to prepare her own case. The judge is making sure of that and giving her all the tools she needs to do this appropriately. Number one, because it's fair. And I think the judge cares and he wants to make sure. And I think the state cares. And everybody wants to make sure that she has a fair shot at this. But also, number two, it protects against appeal because she's going to complain about everything and how unfair everything is about this. And it is unfair and difficult that you would have to represent yourself. But the judge makes it absolutely clear. She made this decision with her actions. She forfeited this right. It is nobody's fault but her own. And the judge has made that clear. So even but for that, he is going to give her all the tools she needs to do the best that she can in representing herself.
Will be completed in IMS for every issuance of the laptop and USB device to yourself, Ms. Boone. The discovery was provided at the court previously and is in the two bankers boxes that are in front of the court to your left, Mr. Lane. I'm going to order you, sir, to take possession and custody of that discovery that was provided to the court previously on June 28, 2024. You, through prison break investigation, shall copy all of the discovery onto as many USB jump drives as necessary. The Judicial Administration Commission for the state of Florida shall be responsible for the fees and costs due to prison break investigations for copying all of the discovery onto as many USB jump drives as necessary.
So the process is this bald guy we're looking at here who's an investigator is going to go through all the discovery, copy it all, make sure it's all there on as many thumb drives. He's going to put the thumb drives in the computer, make sure they work, confirm it's all there, working appropriately. The court can't do this. It's got to be kind of an unbiased third party. He is her investigator provided by the state. So if you're wondering who's paying for all this, who's paying for the computer, who's paying for all the thumb drives, as many as is necessary, who's paying for this guy's hourly rate? Well, it's me. It's you. If you live in Florida, it is the taxpayers of the state of Florida, and everybody who is the citizen here who contributes to all state-funded provisions here in the criminal system, public defenders, investigators, and the materials necessary, including a computer, including thumb drives. We are paying for this for Sarah Boone to make sure she has everything she needs to have an appropriate and effective defense of herself in her own case.
You will appear for a hearing with the court on August 1st, 2024 at 8:45 in courtroom 12A of the Orange County Courthouse with the discovery and all USB jump drives containing the discovery. A representative from the Orange County Jail shall also appear for that hearing as well. At that point in time, prison break investigation shall hand deliver all USB jump drives containing the discovery to the representative from the Orange County Jail in order to be placed onto the laptop that is currently secured and to be issued to the defendant for all trial and court preparation. Do you have any questions for me, sir?
I have a conflict for August 1st, Your Honor. I'm
Okay.
going to be out of state from Tuesday until Friday next week, which I believe is the conference office first.
So he has a conflict in the dates, and he's got to push it back basically to August 5th, and we're going to hear what Sarah Boone thinks about that.
My son's wedding.
Okay, well, congratulations. When do you return from your son's wedding, sir?
I will be back late Friday evening, so I'll be available the following week.
Okay, will you be able to complete that task by that time?
Yes, sir. I'll do my best.
Okay, sir, we will see you on give me a second. I'll make sure the date. Monday, August 5 at 8:45. Okay, you'll be given a copy of the order that I just read from. Ms. Boone, you'll also be given a copy of the order. Do you have any questions for me?
I am thoroughly confused.
Isn't that a loaded question? He's going to brace himself, I think, every time he says, do you have any questions for me? And she's got questions.
And you'll also be given a copy of the order. Do you have any questions for me?
I am thoroughly confused. Was a notice ever put online for this or mailed to anyone? I don't even know why Mr. Lane is here. I don't know why I'm here.
Well, ma'am, you are now representing yourself. And previously you had requested to appear at every hearing that was held. As you are
She's like, I don't know why I'm here. The judge is like, you've asked to be here every time, and I'm going to make sure you are, especially now that you're representing yourself.
now representing yourself, the court previously who had requested to appear at every hearing that was held. As you are now representing yourself, the court cannot have any hearings regarding your case without you being here. I put on the record and explained to you the process that the court has had with communications with the jail. I'm not allowed to look at any of that. I'm not allowed to copy any of that. So in speaking with the jail and understanding that you still have a private investigator that was provided to you through the state that's being compensated by the state, you're still allowed to utilize his services. The protections of the attorney-client privilege are still applicable to him. So he's able to review any of these documents, ensure that they are safely copied without violating any terms of the privileges. Those will then be placed on multiple USB drives and provided to you. Those USB drives will then be uploaded to a computer that has been secured for you at the jail for you to access all of that information.
Okay. My question is, was a notice of hearing posted or mailed to anyone to where apparently the news crews obviously got it? How is it that I do not know anything about this other than my bunk being kicked at 3 o'clock in the morning telling me I have court?
Ma'am, I have no other way to get in touch with you other than setting the hearing, which was set yesterday once I received confirmation.
He's like, we're moving this as quick as possible. It's the only way I can get a hold of you. Notices of hearing don't get to you any quicker than one day where I'm going to send somebody to pick you up and be here because you want to be here. So we're doing the best we can to move your case. You're not going to get months and weeks of notice of every single time we show up. This is purely procedural. You don't really have anything to say about it. You can't really object to it. If you want the discovery, this is the way we give you the discovery. We just want you here so to keep you abreast of what's going on in your case. And everything he's saying is totally appropriate and correct so far. Now, she's going to make it seem very difficult because, again, like a good defense attorney, make it seem like everything's difficult, make it seem like everything is, violating your client's rights and things like that. And you lay the record to where if it really goes overboard, we have a record laid of all these little things that you may have done that violated the rights that turns into one big problem.
From the jail as to the processes for how this would work. And I understand that your case is important and I want to move as efficiently, as diligently as possible. I know that you've been waiting for this information and it took some time to confirm the process with the jail. You've advised me that you have very limited space. You have almost no privacy. You have a small drawer where you can keep some personal effects. We could not send all of those boxes with you to the jail, and the jail advised me that they cannot take all those
all totally logical and make complete sense.
boxes. A process had to be created to make sure, and this is the process.
The process that I was explained after speaking to a couple of sergeants, and I've been waiting.
Speaking to a couple of sergeants, and but she didn't finish who else she spoke to about it. And now she's going to say she was told a different process than the judge. And we got to be careful because we know when she's told different processes, she accuses people of lying. So the judge, has to be careful for how he explains things to her. And I think he is being careful. And she's going to kind of explain the process she thought and what she wanted to happen here.
Waiting for that, and I would much rather prefer a hard copy of these to where I can write on them as opposed to anything that's on a laptop.
I'm unable to provide that for you. I have been provided the process has been provided to me by the Orange County Jail. I understand that's your preference, but I can't do anything more than what I've done right now.
I understand. And I have had other information given to me, which is why I've been waiting for the boxes for them. So I don't know, is this something that I need to pursue continuously still for me to be able to receive my hard copies? Because no one tells me anything.
I cannot answer that question because that may call for me providing you legal advice, which I am prohibited from doing.
And that's going to be a rule he's probably going to have to cite a lot because he cannot provide her legal advice. He should not provide her legal advice, and he doesn't want to provide her legal advice. She's going to continue to ask for it, though, I think. We're learning kind of what this interaction is going to look like during the trial and even before the trial.
Okay. Well, because I have no other way of contacting you other than in a letter, and it's AKA worldwide. So am I supposed to go back and speak?
I feel like she loves the worldwide nature of it, but she's not wrong.
Whoever else it is that I might need to speak to in order to receive these?
Again, I cannot answer that question. All I can tell you is that we will have a hearing on August 5, whereby
She's 100% correct. This sucks. This is hard. This is not how it's supposed to be. You're not supposed to be representing yourself. And I always, this is why we talk about this so much. And I caution people and I caution clients and we talk through these issues. But A, the grass isn't always greener. And B, respect the process. Try to work with lawyers because you end up in this position. It sucks. There's no doubt about it. This is not how it's supposed to be. I feel for Sarah Boone and the fact that I wish she did not end up in this situation, but I think it has to do with a lot of her actions that brought her here, right? And so now looking back on them, was it worth it to really, push hard and fight with all of these different lawyers to get here or to try to work with them and come to some kind of agreement how you can work together and really try harder at that before ending up here?
which prison break investigations will provide all of the information on USB drives. Those will be provided to a representative from the Orange County Jail who will place all that information on a laptop for you to use, and that's accessible for your use from 0800 to 1600 every day.
Right. Okay, so I guess I will figure that out because if I'm up at 2 o'clock in the morning, I can't utilize the laptop, which is another reason why I was looking forward to the hard copies. So my other question is my time prorated for the time that I've been waiting for my discovery?
I'm not sure I understand what that means.
Well,
Is my time prorated for the time I'm waiting for my discovery? So that's not a legal term, really. That's not really how we would ever use it as a lawyer. But what she means is am I going to get additional time tacked on before my pretrial or before my trial starts because I don't have my discovery and I've been delayed in being able to prepare? And Taylor has made a similar argument, and the judge has done that with the speedy trial waiver. If you remember, he kicked that out, waited to set the trial date, and said he would extend deadlines because of the time she's had to wait for X, Y, or Z. So Sarah Boone, using a similar argument here, asking to push that. It's not really how it works with trial, especially when she probably has seen some of this discovery that she's waiting for, but she's going to try. And it's her first attempt, 8 minutes into her first hearing, representing herself, already asking to delay the pretrial and likely the trial.
I be having additional time added, or will it be extended from the time period of me waiting for my discovery still?
I'm not in a position to answer that question. I don't know what it is that you're asking for.
My pretrial is supposedly set for September 24th, I believe it is. So obviously I will not be prepared. And obviously I do not know what I'm doing. And obviously I'm still waiting for my discovery. So for that time period that I have been waiting for almost 4 weeks now, will that be added to the time frame in order for me to be properly prepared?
As of right now, the dates are what the dates are, ma'am.
Okay, so I just missed a week, a month.
The dates are what the dates are.
So I also sent you.
Yeah, I mean, just with how he said that, I'm starting to get an indication that at some point I think he is going to grant a small continuance. I hope it's just a small one, to give her more time and maybe pack all of these together, because she's going to have multiple other complaints and reasons to kick it along. And he may say, listen, you had a delay getting discovery, X, Y, or Z happened. So what I'm going to do is I'm going to give you a 2-month extension. This is the only one, the one and only. You will have no other continuance while you're representing yourself. So be ready by December 1st or whatever he continues it to. So that's the feeling I'm getting. I don't know that for sure is going to happen.
I believe 5 motions. Have you received those?
No, ma'am, I have
She
not.
said she has filed 5 motions. I looked at the docket right before filming this video. I did not see them, but I can't wait to see them.
The
They were
only,
mailed last week.
then I have not received them yet. The last correspondence I got from you, ma'am, was received on July 8th.
5 motions I've mailed. They're probably sitting wherever else it is, considering it takes a day for you all to receive my mail, considering I'm right down the street from you all. So I have those also in order, which may change whatever information or anything that I'm trying to acquire in between now, the month less that I have in order to prepare for my trial. That's in October. So if you could keep an eye out for those also. I don't know how.
Not the most respectful tone, but fair.
Who I'm supposed to ask, how did Mr. Lane come into any of this? Like, how was he
Mr.
called?
Lane has been your investigator in this case, and he was advised to attend this morning's hearing by virtue of being provided the discovery in order to digitize it so that you can have access to it.
So this is part of the argument where I think she has some legitimate gripe if she really has no clue who he is, and he's been supposedly working on her case as her investigator throughout this case, and she has no clue. She probably should know, but on second thought, why is she complaining? He's helping, he's copying the discovery, he's making the process work faster, he's getting the discovery to her, which is what she's been begging for, and saying her constitutional rights have been violated, and he's here to help with that, yet she's still complaining. So, it's kind of two sides of the coin depending on how you look at it.
Contacted him?
I did not contact him.
Am I allowed to speak to him directly?
You can.
So here we go. The first questions asked by Sarah Boone on her behalf as her lawyer to a witness-ish in the courtroom.
Mr. Lane, who contacted you in order for you to be here, please?
JA.
If I'm pro se and my own attorney, shouldn't I be included in all of this so I know what's going on and not a surprise hearing like it is again for the second time?
Ma'am,
She seems to be settling in comfortably to representing herself and being involved in all communication. She's going to push. She's going to fight. She's a fighter. There's no doubt. There's no doubt about that. She is going to push. She is going to say what she thinks and what she believes. It's going to be an interesting thing to watch here. She's not going to roll over. She's not going to get bulldozed by the process. But what is she going to say in front of the jury? Is she going to say my rights have been violated? This is so unfair. I didn't even want to represent myself. Is she going to say things like that in front of a jury? Because you can't. And those can create mistrial opportunities. And if she does that on purpose, who's she really going to hurt? Right? Like, what's the judge going to do? Keep her in prison? So I'm interested to see how far she really pushes this line in fighting for her life.
again, this is why there were benefits to being represented by counsel. The court has already identified in its 16-page order the reasons for why you no longer have those benefits.
Right. Which
It
is
makes
now
things
formed.
exceptionally more difficult, as I explained to you, in communicating with the court and communicating with the state attorney's office.
Isn't that what a certificate of service is for anything that's filed by anybody in the court?
There
That
was,
should be included in that.
ma'am, there was no certificate of service for setting this for today. This was coordinated by the JA. You were advised as soon as it was set yesterday.
It's It's just very odd to me that the news.
It's
media-
totally appropriate just because they're trying to push this as quick as they can procedurally to get her the discovery. In other circumstances, we may say, oh, that's totally unfair. You have to give the defendant an opportunity to prepare. You have to give the defendant an opportunity to make their arguments. But in this case, what is her argument going to be? Maybe she wants to say Mr. Lane is in cahoots with the state and he's doing something to hurt my case and he's not really on my side and she didn't have an opportunity to investigate that. Okay, maybe. I mean, it's far-fetched. But do you want the discovery or do you not? If you're objecting to Mr. Lane or you're objecting to how quickly all this was thrown together, your almost 4-week delay would be almost 5 weeks or 6 weeks or something like that. And nobody wants to create more of a delay in this case, except for maybe Sarah Boone at this point.
Before I did.
Again, I can't speak to that.
And so nonetheless, my constitutional right to counsel is being forfeited on your behalf in the court. So now I don't get appropriate notice in preparation for me to be able to be here and doing what I'm supposed to be doing and act as and perform as.
I've already addressed the reasons, ma'am, for why there was a forfeiture and alternatively a waiver in the 16-page order that you were provided. Again, it's difficult to communicate with you based on where your current housing is. I'm not able to pick up the phone. The judicial assistant's not able to pick up the phone to communicate with you or send you an email to schedule certain things. And it leaves a little bit of the level of further complication.
Obviously, because you're in jail.
How is it the news knows before I do?
You keep asking the same question and the answer is going to be the same. I cannot answer that question for you because I do not know.
He doesn't tell the news, obviously. They can get it through the public record. They can have people on the inside. I got to be honest with you. Immediately when stuff happens in Sarah Boone's case, multiple people email me and DM me. The news has, I don't even search for that or try to get people to do that. I appreciate it, of course, and we cover it and we talk about it when we have time. But the news people that have their sources, they want it. They push for it. I'm sure they get it immediately. And in Florida, it's not hard to get.
Okay, but you do know it's harder for me.
I would agree with that, yes.
And you do know that you did not ask me any questions in regards to your order. You just read it straight off and never asked me what's what or how many, if anything of it.
Ma'am, if you have questions, I can certainly try to answer them. I'm trying to facilitate you getting that information that you're certainly entitled to. And it took time for a process to be created by the Orange County Jail. As they had advised me, they do not have a place to store 2 bankers' boxes of information, nor are they in a position to provide you physical copies. This is what I've been advised as the process is. As soon as that process was finalized, I set the hearing. This was finalized yesterday.
No one ever asks me. I've been waiting for the boxes. I really don't know what to say. And because I supposedly have no way to contact you other than a letter, and the same for you, I don't know how the news crews got here before I did. But I don't know going forward, how is it that I'm supposed to be able to communicate with you other than me sitting here in front of you at these, I guess, supposed surprise hearings I'm going to have every single time that it is that you would like to speak to me? Is that
These supposed surprise hearings? She's really, I mean, she's going to take shots. The judge, I have a feeling, is going to handle himself with grace and patience. He has done so far. I wonder to see if that changes in front of the jury if she continues to push the line, because that's inappropriate. But he will probably also know, as I found out when I tried a case as a prosecutor against a pro se defendant, the jury also picks up on the snark and the nastiness, and they don't like it. They especially don't like it if you direct it towards the judge. So if Sarah Boone is watching this, or somebody that talks to Sarah Boone, respect goes a lot further. You catch a lot more flies with honey than you do with vinegar, especially in front of the jury. So these antics, even if some of them are for the cameras or for people to watch, so she really wants people to understand how hard it is for her, how difficult, how unfair it is for her, in front of the jury, it can really blow up in your face. It can really backfire.
what it's going to be?
Ma'am, I cannot answer that question. All I can tell you is that you can communicate with the court through the avenues that you've been utilizing previously by and through letter writing. As I said, I do not have your letters that you sent last week. They're not in the court file, and they were not in my inbox yesterday. So as soon as I receive them, I will diligently review them. And if we have to set a hearing, you'll be properly noticed for it.
In the certificate of service.
You'll be properly noticed for it. Yes, ma'am.
And will there be a proper notice for today?
Notice was performed last night. I've already explained.
Ask the news crews how they got here?
No, ma'am, I'm not going to let you do that. They're not under oath. They're not a party to this action right now.
It's wrong and it's unfair.
You're certainly entitled to that opinion.
And
I mean, he even like respects her opinion. He's respectful for it. He's not going to let her make a mockery of the courtroom and start asking all the news crew and everybody sitting in the gallery how they got here. Necessarily, it's a public open forum. They're allowed to be there. They're not doing anything wrong or illegal. But I also understand how she's annoyed about that, right? It's her life, and the news crews get the information before her. It seems like everybody knows things before she does. That's also frustrating and annoying, and I get that, and I sympathize with her for that. I know a lot of people don't. I know a lot of people don't like her, but I'm just saying, like, she's a human being. She's a person, and she has rights as well. And while I think she has, done things wrong or tried to manipulate or push or force those rights in different ways that might not be appropriate, she has a right to be frustrated that she feels like the public is getting more information, has more rights than she does with her own case. So I get it. I don't think she's right about it, but I understand her frustration.
I want to ask him a question.
Sure, go ahead.
Mr. Lane, how is it that you and I are supposed to be speaking to one another?
So my suggestion would be, since you're now the attorney and you are pro se, that either you or your honor gives me access to the jail to come visit with you, and I'll be happy to do that. It is the policy of the Orange County Jail to have a letter represented from an attorney to allow me to access you. That's the reason for the past previous couple of attorneys have not had the ability to come out and access you, but that's changed. I'll be happy to continue to move forward with any investigative actions that can be for your defense.
He seems very respectful and nice. I hope he knows what he's asking for. He said, any investigative tactics we can work for your case. My guess is she has some ideas. And again, he's getting paid by the state. So he's respectful. He tells her we can come meet in person. I'll do it just like the other attorneys came and met with you in person. I need to get access for the jail. He even explained to her the different ways he can get access. Usually it's through a lawyer, but maybe the court can set up an opportunity, or the jail, for him to get access to her through visitation.
So you need a letter from me,
Or the judge or the jail, somebody that will allow me access to you. Yes, ma'am.
and I send it to you directly?
Yes, ma'am.
Is this a letter also that you'll be supplying to him?
I don't know that I'm in a position to compel the Orange County Jail to do anything,
But you are the ones who contacted him.
but I can't tell the jail, let this person come talk to you.
He kind of could, but
If they have a policy where you need to provide the letter, then you need to provide the letter.
So until you have that letter, you and I will not be able to speak with one another?
I will contact the jail myself and find out if there's potential to pro se, or maybe they can speak to you directly.
can't really hear him, but he could have kicked this down the road, but it sounds like he said, I'll contact the jail. I'll try to make this happen to help you.
So you certainly get the actual letter itself.
Thank you.
Ma'am, do you have any other questions?
I don't think you have enough time. I'm just doing my best, and if you could please keep an eye out for my motions.
I will be on the lookout for them. You said there were 5, correct?
Yes.
I will
And
be
if you
on-
could please include me on the certificate of service for whatever hearings that we have that are no longer a surprise for me, please.
Understood. You'll be given a copy of the court's order that I read momentarily, and I will see you both on August 5 at 8:45 in the morning. All right, thank you all very much. Mr. Cacciatore, anything further, sir?
Nothing from the state.
All right, thank you very much.
Thank you, Your Honor.
Thank you, sir. Have a great day. Oh, wait, before you leave, that is all going to be yours. Yes, I would, sir, so that you can begin the digitization process. All right, I'll see you on the 5th. Perfect. Thank you, sir. Yes. Ma'am, I'm just.
So this a little bit reminds me of some of the things that other judges have not liked when news cameras zoom in on criminal defendants' faces. I'm sure there'll be comments about it and people talking about it. We're not going to do that here, but this is an example of what in other cases like Lori Vallow, the judges have either limited cameras, removed cameras altogether because of zooming in on the defendants' faces from different news organizations. All right. So it doesn't look like we missed anything there. So it begins. Sarah Boone representing herself, asking questions on her behalf, speaking to the judge, making arguments, writing motions. She's written 5 already. I can't wait to read them. If you guys find them, send them to me. We'll break them down. We will talk about them. So I want to get this to you as quick as I could. Hopefully you guys have an amazing Friday before the weekend starts. And that's it. Hit the like button, comment, subscribe, all the YouTube-y things. You guys are the best. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.